Welcome back to Amber Community's podcast series. My name is Sarah Richardson and I'm a Senior Associate at Arnold Dallas McPherson. And I have my colleague here with me today, Sean.
Hello, my name's Sean Marcus. I'm a partner of Arnold Dallas McPherson. Thanks for having me.
Sean, today we're going to talk about the third no-fault entitlement, or what we might describe as the third no-fault entitlement, which is impairment benefit claims, and also touch on dispute resolution applications. How would you describe to a potential client what an impairment benefit claim is?
Yes, thanks, Sarah. It's a type of claim that the legislation allows someone who has experienced road trauma to bring a small claim, relatively small claim for compensation for the injuries which have happened in an incident, and those which are long-standing, which might be of the type that are permanent in nature. And we generally assess that about 12 months after the incident has taken place.
I think another key word that comes up when we're talking about impairment benefit claims is stable. So the legislation says 12 months or stable, or the guides say 12 months or stable. What would you say when would you say an injury is stable?
So an injury is stable, not when all treatment's finished, but when major interventional treatment has finished. So there might have been a surgery after an incident. There might have been multiple treatment options after an incident. But once the injury is stabilised, is generally considered that there may be things like physiotherapy or other physical therapies taking place as an improvement continues slowly after the incident. But that's generally considered enough recovery time for an impairment claim to be contemplated.
Yeah, and I guess when we're talking with clients, that's something that we assess on an ongoing basis. So we touch in month by month and see how things are going, and then decide when it's time to get going with an impairment claim when it looks like an injury stabilising.
Correct. And it's a balancing feature that we try and make sure that we resolve someone's rights as practical and prudently as possible, but with also balancing that with other treatment that is being considered following an incident.
And the legislation describes a threshold for whether or not someone is entitled to an impairment benefit claim. Can you try and describe or explain how that works?
Yeah, that's correct. So the legislation sets out a minimum level of impairment of 11% of when we calculate the different impairments that may exist following an incident, and we add those different values together under the relevant guidelines which we have. And that impairment rating equates to a certain amount of compensation dependent upon the date of when the incident took place.
I think it's important that we discuss and touch on the work that's done in the lead up to making an application with the TAC to ensure that clients have the best possible opportunity to meet that threshold. And we do that we do a process of gathering information through medical records and medical reports in order to get an impairment claim ready to lodge. I think that's an important part of the process, but it does take some time, sometimes months.
Yeah, correct. And so also, sometimes your lawyer will interview you and discuss all the injuries and make sure that even more minor injuries, which may not be the main injury for which you've received treatment for, is considered, so that we can gather the right evidence and have each and every impairment that may have come from an accident considered.
Yes, and I think probably a point to make is that people or lawyers who have experience in this area of personal injury law, it's important to have a specialist in that we know what kind of things to look for. And in the next part of the process, which is organising specialist medical examinations, we know which doctors our client should go to.
Correct. It's a very specialised field. The types of doctors who perform what are known as JMEs, joint medical examinations, which is a specific medical examination conducted between someone's lawyer and the Transport Accident Commission to assess the different types of impairment in order to work out the entitlement to the percentage of payment.
And so it can take some time to get medical examinations organised, and there's often a waiting period between when an appointment is sought and when an appointment is arranged. It can be months.
Correct.
And so I guess there's some patience involved in that process.
Yes, typically we would suggest it's about a 6 to 12 month process.
Yeah. And so once a client goes through that process, the TOC will review the information and collate the information and generally write or put in writing a determination as to what they say an impairment benefit might be. At that point, what would you suggest a client do, or what are the options thereafter?
So the proposal made by the Transport Accident Commission, your lawyer will consider that with you and provide you some legal advice about whether or not it's a fair reflection of the nature of the injuries with their experience for which the proposal sets out. If that proposal is not something that fairly reflects the nature of the injuries, your lawyer will give you advice about the appeal mechanisms.
And so I guess that's where we can jump into what we describe as dispute resolution applications. So that is a process that's available if you dispute the initial determination of your impairment, but it's also open if you have a dispute with respect to the other no-fault entitlements we discussed last time we were here, being income support and medical like spaces. There's a time limit on when you can make a dispute resolution application, so it needs to be submitted within 12 months.
Yep, correct.
And what's your experience with the TAC once one of those applications has been made?
So the Transport Accident Commission and an organisation called the Australian Lawyers Alliance, which I am closely bonded to, have set out a set of guidelines which allow for most disputes to be resolved without needing to litigate. So the whole aim of the dispute resolution process is to try and sort out what dispute, whether it be a medical entitlement, a weekly payment entitlement, or an impairment entitlement dispute, in a very set out way that allows for both any dispute to be properly considered by the Transport Accident Commission prior to needing to resort to litigation of any type.
Yeah, excellent. I guess just reflecting on the conversation we've just had, although we're trying to break this down and make it quite simple, they are complex in processes by their nature. And I guess probably just to finalise this episode, we probably should reinforce that we're here as legal guiders at all times, and it's a good idea to reach out to a lawyer such as ourselves for assistance. Thanks, Sean.
Thanks,